are less questioning of the police, and this could be based on culture, age, background experience, whatever relationships, whatever it may be. Different people think differently of the police. I would say, with that being said, though, we are living in an environment right now that the police have been kind of in the spotlight of being on the bad side of things. Not all. I even think that may be an advantage. It could be a disadvantage because I think a lot of people, there's people that like that and agree with that, and people that hate it and think that.
And I mean, there's two sides. Like that was kind of my worry with this case. Is in Clinton County, we're in blue line, respect the blue line territory is kind of what I thought. Because of the polarization of our country, there's sort of the Black Lives Matter. If I had a case like this in Detroit, I would have felt a lot more comfortable. But when I had an all-white jury that there wasn't a single person under 40 years old and most of them were above 60 that showed up to this jury pick during COVID or whatever, a worry of mine with the case is, are these those people that watched the Jacob Blake video and said he should have listened to police? Are these the people that said, like, that are constantly saying, defending the cops and George Floyd, that will almost put their blinders on to police misconduct because you should do what police tell you to do? Because if that's the way they felt, I had a tough case ahead of me.
Right.
Because my client was not listening to the police.
Now, here's something that's interesting. For up until this case that I had in 2013, I think it was, I've been practicing since 1992, 93. The state of the law in Michigan had always been that if you were charged with the crime of resisting and obstructing, your only defense that you could potentially have would be, I was not resisting, not obstructing. You cannot argue that I was being unlawfully arrested and was justified in arresting. You cannot say that my constitutional rights are being violated and I was resisting for that reason. You were limited 110% from never being able to say that you had a justifiable reason for disobeying a police officer's command, order, or even pulling away from if there was an arrest taking place.
You do what you're told.
So, in the case that I had, knowing that to be the case, there was, in the middle of, I think we picked a jury on a certain day, 2 minutes left, picked a jury on a certain day, and before we came back to begin the trial, the Court of Appeals first it was the Supreme Court, then there was a Court of Appeals case. Moreno was the first case, then there was another one, Yena or something like that, with a Y, I think the case began. But anyways, what the case essentially said is that the resisting and obstructing statute did not preclude the requirements of the common law right to resist a police officer or law enforcement agent if you were in a constitutionally protected area. And thus created this new element, essentially, for resisting and obstructing cases, which included, amongst other things, that in order to charge someone with a resisting, obstructing, or convict them, the person charged had to know that it was a law enforcement officer, that they had a lawful, they had the authority to act as they did, and that they did so at a time when the person was not in a constitutionally protected area. In fact, the case, if I recall correctly, this Moreno case involved a guy who was locked up in his home, boarded up, SWAT team surrounding him, trying to coerce him to come out. They got the negotiators there talking back and forth. And unbeknownst to the guy in the house, Moreno, they get a search warrant to go into the house. And they enter the house telling him. And he jumps on them and fights with them in the front of the door. They charge him amongst the other, things that he was doing, resisting and obstructing. Got convicted, and it went to the Court of Appeals. And the Court of Appeals, in the opinion, focused on this one area. It said, did you tell Mr. Moreno that you had a search warrant when he went into the house? The answer was no. Why did you do it? For officer safety, they said. Well,
for officer safety.
He didn't know that you had a warrant and a legal right to be in there, and he's in his constitutionally protected house, not knowing that you have a legal right to be in there.
He's going to start firing.
He has a right to defend himself within the house under those circumstances, because he didn't know you had a legal right to be there. Someone else brought something up that it's
no different than if someone just kicked in your door in the middle of the night.
They would be required to do knock at least, right? Because there's no knock.
They have to announce themselves. How else, especially if you're half asleep, are you going to know it's the police?
Understood, 100%. Anyway, so that's an interesting factor. But But even with that being said, I remember in our jury selection, I asked the jury pool or the group that had been brought to the 14 seats, how many people can think of a reason why they might disobey a police officer's command? Probably not a great voir dire question, but I asked them that question. Not one hand went up. Not one hand went up. David, you know what I'm saying?
Yeah, I do know what you're saying. You know, I think there's a better way to phrase that, maybe. You know,
but
like what if the police officer told you to kill your child? Would you follow that order? You know, start them light. You know.
Well, I said, well, okay, no. What about if the police officer is standing on the sidewalk outside of your house, calls your name, you come to the front door, you see him or her, and they say, come outside, I want you to confess all your sins to me. Do you have to come outside? Would you go outside? Would you call a lawyer? Would you stay in the house? Are you allowed to stay in the house? Is that command something that you could not respond to, right? And, you know, of course not. They can't make you talk. You have a right to be silent, right? You don't have to. You're in your house. They have no right to order you out.
No, I assure you, if they had a right, they would just come get you.
Right. So, David, I want to talk more specifically about the facts of your case, but I think we should take a break for a minute and come back and talk more about that, if that's okay. Yeah. We may have Jeff Irwin calling in, and if that is the case, we will.
We're gonna
switch topics.
Play it.
Stay in the room, and we'll take a quick break, and we will be right back. Listen to Planet Green Trees, episode number 484. It's called, by the way, we haven't mentioned this, Exonerated, Better Late Than Never. And that will have meaning later on. But the second topic tonight.
The second topic.
We'll be right back.
The Planet Green Trees Show.
Join the Michigan Medical Marijuana Association today. MichiganMedicalMarijuana.org. The MMMA is focused on the well-being and safety of medical marijuana patients. The MMMA site provides the most comprehensive and up-to-date news on legal issues, politics, research, innovation, as well as the various strange products and methods of cannabis use. Come join the discussion with the most knowledgeable and passionate advocates in Michigan today. MichiganMedicalMarijuana.org.
I am Earl from G3 Cannabis Therapy Network, and you are watching Planet Green Trees, the original and #1 podcast in Michigan for all things cannabis and legal news.
Dr. Bud Green here. Welcome to our